So the Fifth Circuit is now going to rule in a case that challenges the NFA and the suppressor restrictions as a violation of the Second Amendment, but some bad things have kind of developed in this case that we need to talk about. Now, really quick before we jump into this video, I want to ask you all for a huge favor. Looking at some of my analytics, about 60% of all my viewers are actually not subscribed to the channel. So if you want to support this channel for free, one of the best ways to do that is simply liking and subscribing to the channel. And then also just double check, because YouTube loves to unsubscribe people. Now, as I mentioned in the intro, in this video, we're going to be discussing a challenge that's currently in front of the Fifth Circuit Court of Appeals, which deals with the constitutionality of the NFA as it applies to suppressors. The case we're going to be discussing in this video is the United States versus Peterson, and this case involves an individual who had a gun store at his home that was raided by the ATF and local law enforcement. During that raid, the ATF found a single solvent trap that was not registered or serialized, and because of that single item, Mr. Peterson was charged with violating the NFA. Mr. Peterson and his attorneys tried to get the charge thrown out of the court by using a motion to dismiss, and they argued that the NFA is unconstitutional under the Second Amendment. The district court denied that motion, finding that silencers are not bearable arms protected by the text of the Second Amendment. That decision by the lower court, by the district court, is now up for appeal and review in the Fifth Circuit. That means that a pure Second Amendment challenge to the NFA as it applies to suppressors is now up for review and decision by the Fifth Circuit. However, some unfortunate things have developed on appeal that we need to also talk about. Now, the facts surrounding this case are very interesting, and both the ATF and Mr. Peterson tell a different story. According to Mr. Peterson, on June 29, 2022, both federal and state law enforcement officers executed warrants at his home in Louisiana. The local sheriff executed a search warrant and an arrest warrant based on delinquent parish taxes. Now, a federal task force was also involved that included ATF agents and then 50 law enforcement officers as well, who also executed a search warrant. Now, according to the ATF's brief, the ATF and local law enforcement went undercover, purchased several firearms from Mr. Peterson, and they claimed that he had an illegal storefront. They claimed that through some of those purchases, they discovered that Mr. Peterson failed to file the paperwork appropriately. And the ATF also claims that they traced about 70 firearms that were sold through the years at his store. They were found at crime scenes and they were traced back to his store. Now, during this raid, the federal agents also seized his entire inventory, which totaled about 300 firearms, and that also included all of his personal firearms. But here is also where things got complicated for Mr. Peterson, which really resulted in this lawsuit in this case. During the search, the ATF found what they determined was an unlicensed suppressor in his personal safe, which was located in his bedroom. Now, out of this whole interaction, no other charges were brought against Mr. Peterson except for the single charge of possessing the unlicensed suppressor. So out of this entire incident, it is the possession of a single solvent trap that got Mr. Peterson jammed up and resulted in his criminal conviction. Now, on October 20th, 2022, he was indicted by a grand jury and charged with violating the NFA because he knowingly received a firearm, and that was a firearm that was not registered, and it was in violation of the NFA. Now, in response to that charge, Mr. Peterson and his attorneys filed for a motion to dismiss. They wanted to dismiss that charge based on the fact that the NFA is in fact a violation of the Second Amendment. Now, on August 21st, 2024, the court denied his motion to dismiss the indictment. Now, on August 29th, 2024, he did enter a conditional plea reserving the right to have the Fifth Circuit review that motion to dismiss and the denial that happened at the lower court. Now, the question presented to the Fifth Circuit is very important. It's whether the district court erred in finding that silencers are not bearable arms covered by the Second Amendment, or even if so, whether Mr. Peterson's indictment for possessing an unregistered silencer violated the Second Amendment. So keep in mind, this is a direct challenge to the constitutionality under the Second Amendment of the NFA's process as it relates to suppressors. Now, I do want to state that when you look at the arguments presented by Mr. Peterson and his counsel, there is no mention at all about the recent New York State Rifle and Pistol Association versus Bruin decision that was issued by the Supreme Court and reaffirmed that the proper form of analysis when it comes to Second Amendment cases is in fact text as informed by relevant history and tradition. Instead, in all of the briefs filed by Mr. Peterson, they tried to use means-end scrutiny, tiered-based scrutiny, which is an older analysis that was expressly rejected by the Supreme Court in Bruin. In fact, the text, history, and tradition standard is much more favorable to the pro-2A side, so it's unfortunate that they're not using the correct precedent because, again, it's pro-2A. Now, interesting, even the ATF uses and argues this case in light of Bruin because that is the correct type of analysis. That's the precedent by the Supreme Court, and they call out Mr. Peterson's counsel for not citing to Bruin appropriately. Now, in the ATF's brief, they first argue that suppressors are not arms protected by the Second Amendment at all. They claim that they are not bearable items and that they are not weapons which shoot a projectile. At best, the ATF claims that they are simply accessories, and as accessories, they are not protected. They then argue that even if these are arms, they are still dangerous and unusual weapons, and that they can be regulated as dangerous and unusual weapons. They point to dicta in Bruin by Justice Kavanaugh, which mentions that shall issue CCW permit schemes may be permissible under the Second Amendment, but now the ATF is trying to take that and argue that the NFA's regulations in that scheme is similar enough to pass the Bruin standard because it shall issue. Also in the ATF's briefs, they point a lot to the recent Fifth Circuit decision, which dealt with the Made in Texas suppressor issue. That was the Paxton versus Dettelbach case. The Made in Texas law was passed by the state of Texas to essentially remove suppressors that are made exclusively within the state outside of the NFA's registration process and the taxation process, and tried to remove the ATF's power over Made in Texas suppressors. However, on review, the Fifth Circuit found that the plaintiffs there and the state of Texas did not have standing, so they dismissed the case. So the ATF here tries to use those arguments made in the Paxton case to also support their position in this lawsuit. In contrast, Mr. Peterson's attorneys argue that the NFA does violate the Second Amendment and that it would not pass means-end scrutiny. Again, I want to mention and point out that this is not the correct type of analysis, that these briefs are framed under means-end scrutiny, which has been rejected when it comes to Second Amendment analysis, but that's what they use. They do not reference Bruin. Mr. Peterson's attorneys argue that the defendant's motion to dismiss must be considered in the context that the indictment charged him with knowingly received and possessed a firearm. Paradoxically, the government now argues that the device for which the defendant received and possessed is not a firearm to deny the constitutional rights of the defendant as provided by the Second Amendment. Now, I do think this is one of the stronger arguments made in his case because when you look at the ATF's briefs and their arguments, they tried to present suppressors as not firearms, as simply just accessories which are not protected by the text of the Second Amendment. But then at the same time, the entire charge in the entire criminal case which Mr. Peterson is facing is based on him possessing an unregistered firearm. So you can't have your cake and eat it too. The ATF is making contradictory statements. Now, one of the concerning things that has developed in this case, and specifically with this appeal, is the fact that Mr. Peterson was supposed to file his reply brief to the Fifth Circuit after that ATF response brief. That would have given him the opportunity to maybe include the Bruin analysis, to address some of these issues. However, they did not file that reply brief. If you look at the docket, it indicates that they had 21 days to file that reply brief, but no reply brief was filed. And because of that, now the clerk in the court has closed the briefing schedules. All the briefs have now been submitted to the Fifth Circuit for consideration. So although this case is primed to address the NFA suppressor issues and address all the issues that we wanted, challenge the NFA specifically in regard to suppressors as a violation of the Second Amendment, now I have a lot of concerns about the basics of this case and a lot of the things just simply not being done. I talked to a couple 2A organizations and I'm trying to persuade them to file amicus briefs to the Fifth Circuit, but we'll have to wait and see what happens with those. But in my personal opinion, without help from an amicus brief bolstering the 2A side, I'm concerned that the Fifth Circuit will ultimately see that there's an easy way out to reject the 2A claims, say that the side didn't even approach this type of analysis correctly, and a decision upholding the NFA's process can have very bad ramifications down the road. Of course, if the Fifth Circuit sides with the ATF here, finding that suppressors are not protected, that the Second Amendment is not implicated here at all, that would not only impact the Fifth Circuit in future suppressor cases and other NFA challenges, but it could also have implications for other jurisdictions who maybe want to cite to what the Fifth Circuit says, because the Fifth Circuit has been very pro-2A, but this case has not been positioned appropriately to challenge the NFA's process under the Second Amendment. So a very interesting case that I'm very concerned about. I wanted to put this on everybody's radar, and if anything else changes, I will let you guys know. Also, if you like this video, and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.